Welcome to Talk Testimonies, the place to be when you want to understand those, well, kind of critical Supreme Court decisions, but without all the headache-inducing legal jargon.
You break it all down, make it nice and simple, just for you.
Today, we're going to dive deep, really deep, into this really significant case. It's called North Carolina Department of Revenue v. the Kimberly Rice Kaestner 1992 Family Trust.
Catchy title.
Oh yeah, super catchy. Anyway, we're going to figure out, can a state tax a trust just because someone who might benefit from it lives there? You know, one of our wonderful listeners actually sent over the whole record of the oral arguments for this case, so massive thanks to them.
Yeah, they're the real MVP.
And we've done the heavy lifting and pulled out all the really important stuff.
All the good bits.
Exactly, all the juicy details.
So the big question the Supreme Court was wrestling with was this. Could North Carolina actually tax the income of a trust that's, situated and managed in New York just because one of the people who might benefit from it, a beneficiary, happened to live in North Carolina?
Okay, so right off the bat, we've got this clash, right?
Absolutely.
It's like a legal tug of war.
It is. You've got the North Carolina Department of Revenue. They're like, hold on, under trust law, the beneficiaries, they're the real owners of all that trust income. And since North Carolina is looking out for its residents, providing them all these benefits, we're totally justified in taking a slice of that trust income. It's only fair. Due process,
Due process clause. Yeah, just a quick reminder for everyone, that's the 14th Amendment thing that basically says the state's got to play fair when they're using their power, especially when it comes to taxes.
Makes sense.
Now, on the other side, you've got the Kimberly Rice Kaestner 1992 Family Trust pushing back hard, saying, whoa, hold up. Taxing us just because someone who might maybe someday get something from the trust lives in North Carolina. That only violates due process.
Yeah.
Their argument was all about where the trustee was and who was actually controlling the money. That's where the real connection is, not just where some potential beneficiary happens to be living.
So at its core, this case is all about a state trying to reach across state lines with its taxing power.
And the Supreme Court's got to figure out if that's even allowed.
Yeah, where's the limit? And this all plays out against the backdrop of trust law, which can get kind of complicated.
Oh, tell me about it.
Let's break down North Carolina's side first. They really went all in on the idea that trust beneficiaries are like the ultimate owners, at least when it comes to the income. Their Solicitor General, the guy arguing the case, flat out said beneficiaries are the true owners of trust income under trust law. They kept hitting on that point. And then they kind of played the we're just looking out for our people card.
You mean like providing services and protection to residents?
Exactly. They were basically saying, hey, we offer all these great things to folks living in North Carolina, so it's only right that we get to tax some of that trust income that ultimately belongs to those residents. They even threw in the term pro-rata, which just means proportional, based on how many beneficiaries live in North Carolina.
So they're trying to tie the tax to the beneficiaries and the benefits they're getting from the state.
Precisely. And to make their case even stronger, they brought in the Stewart case, which is a past Supreme Court decision. They claim Stewart gave them the green light to tax, even if the beneficiary hadn't actually seen the money yet.
But I think Justice Ginsburg wasn't so sure that Stewart actually applied here. She even asked if North Carolina could tax beneficiaries on income that was just piling up in the trust, before they could even touch it.
She was definitely poking holes in their logic.
And it does make you wonder, right? If Stewart really supports their argument, why is there even a debate?
Good point. North Carolina tried to explain that difference, saying, hey, we're taxing the trust itself at this stage, not the beneficiary directly. But they still stuck to their guns, arguing that, in the grand scheme of things, that income truly belonged to the beneficiaries, according to trust law.
So they're trying to have their cake and eat it too.
Kinda, yeah. Now, let's dig a little deeper into that pro-rata thing. How did that work in practice?
Yeah, break it down for us.
Okay, so imagine a trust with, say, 5 beneficiaries. 2 of them live in North Carolina, the other 3 are somewhere else. According to North Carolina, they could tax 40% of that trust's income.
40%?
Yeah, because 40% of the beneficiaries are in North Carolina. They said they could do this even if those North Carolina beneficiaries didn't actually get any of that specific income during that year.
So even if they didn't see a dime of that 40%?
That's what they argued. And that's where Justice Breyer really jumped in. He was super concerned about this whole pro-rata thing, especially when you consider that some beneficiaries might never even see the money, or they might get it way later when it's worth less. He was like, how can you tax someone on income they can't access and might never even receive? He even gave this example of a trust with 100 beneficiaries, and only one of them lived in North Carolina.
So 1 out of 100.
Right. And that one beneficiary, they might eventually get a tiny little sliver of the trust, but North Carolina could still try to tax a huge chunk of the income based on that one resident.
That seems a little out of whack, doesn't it?
Yeah, Justice Breyer definitely thought so. Now, North Carolina did try to address the whole double taxation concern. They pointed to their own law, Section 105, 160.4, which basically gives people a credit if they've already paid taxes to another state.
So they're trying to prevent people from getting hit with 2 tax bills for the same income.
Right. But then Justice Ginsburg hit them with another zinger. Are you constitutionally required to offer that credit?
Oh, good question.
North Carolina kind of sidestepped that one, saying most states have similar credit laws anyway. But then they shifted gears and started talking about the bigger picture. They argued that if the Supreme Court ruled against them, it could throw a wrench into how 33 states tax trusts.
33 states. That's a lot.
Yeah, they were basically saying this decision could have massive implications. They even brought up a case called fielding, where someone moved the trust to a state without any income tax right before a big payout.
So they're saying this could create a loophole for people to avoid taxes.
Exactly. And their main point was that the beneficiary living in North Carolina, that connection, that should be enough for due process. They kept stressing that this was the first trust tax case the Supreme Court had seen since 1947.
So they were kind of saying, hey, this is new territory, give us a break.
Yeah, sort of. Okay, so that's North Carolina's side. They were all about the beneficiaries being the ultimate owners and the state's right to tax them. Now let's flip the script and see what the trust had to say. They focused on the trustee, the person actually managing the money, and how uncertain it was for the beneficiary to actually get anything.
Makes sense. So what were their big arguments?
They hammered home the point that the trustee, who's chilling in New York, was the one in control. They had possession of the trust's assets, and they had a legal duty to act in the best interest of all the beneficiaries, not just the one in North Carolina. And they made it super clear that the North Carolina beneficiary couldn't just waltz in and demand money from the trust. They had no immediate access, and there was no guarantee they'd ever even get a penny.
So the trust is basically saying this beneficiary in North Carolina, they're not really a factor in how the trust is managed or where the money goes.
Exactly. And they kept bringing it back to the basics of income tax. You should only be taxed if you actually possess, control, or receive the income. They did their homework and claimed that North Carolina was basically the only state trying to fully tax a trust's accumulated income just because a beneficiary with no guarantees lived there. They mentioned Tennessee got rid of its income tax altogether, and even Georgia's law was kind of murky on this specific point.
So they're portraying North Carolina as this outlier, going rogue with its tax policy.
Right, trying to paint them as this greedy state overreaching its boundaries. They also highlighted how much power the trustee had under New York law. They could decide how to distribute the money, and they could even extend the trust's life without the beneficiary's consent.
So the trustee's calling the shots, and the North Carolina beneficiaries kind of stuck on the sidelines.
Exactly. And this totally undermines North Carolina's claim that the beneficiary is the true owner for tax purposes, right?
Right. It's like, if they're the owner, why can't they even touch the money?
The trust then brought up this really interesting analogy. They compared it to corporations and shareholders.
Oh, that's a good one.
They were like, imagine if a state could tax a company just because someone who owns stock in that company lives there. It would be chaos. That really drives home the potential for abuse if North Carolina's logic was applied more broadly.
It would be a free-for-all for states trying to grab tax revenue.
Totally. They also challenged North Carolina's argument that the beneficiary's move to the state created a connection strong enough for taxation. The trust basically said, nope, that's not how it works. The trust itself didn't choose to do business in North Carolina, so the state can't just claim jurisdiction because a beneficiary moved there. They even cited some legal heavy hitters, like the safe deposit case and Hansen v. Denkla, to back up their argument.
So they're bringing in the big guns of legal precedent.
They are. And then the trust actually offered an alternative way North Carolina could tax this income. They said, hey, what about throwback taxes?
Throwback taxes.
Yeah, those are taxes that kick in when a beneficiary actually receives the income, even if it was earned years ago when they lived somewhere else.
So it's like, okay, you finally got your hands on the money, now we can tax you.
Exactly. That seems much fairer, right? It connects the tax to the actual benefit received. And the trust was careful to distinguish this case from a wealth tax, saying, A wealth tax might be okay if the beneficiary actually had a current guaranteed right to the property. But in this situation, the beneficiary's interest was totally up in the air, controlled by the trustee.
So the trust is drawing a clear line between taxing something concrete, like actual possession of assets, versus taxing something that's totally uncertain and might never materialize.
Precisely. Okay, so we've heard from both sides. Now let's put on our imaginary robes and step into the Supreme Court chamber.
Let's see what the justices had to say.
Oh, they had plenty to say. And they didn't hold back.
They never do.
One of the big themes that kept coming up was fairness. Like, is it really fair to tax a trust just because someone who might someday get something from it lives in a particular state, especially when they have zero control over the money right now?
Right, like where's the actual connection?
Justice Ginsburg really zeroed in on that timing issue. She kept asking, can you really tax income before the beneficiary even gets it? She even wondered if a property tax based on the actual assets in the trust would make more sense if the beneficiaries are considered the true owners.
So she's questioning the whole premise of taxing income that's just sitting there, potentially for years.
And as we talked about earlier, Justice Breyer was super concerned about that pro-rata approach. He thought it was fundamentally unfair to potentially slap someone with a huge tax bill for income they might never even see.
Justice Sotomayor also had some sharp questions. She really wanted to know how North Carolina could claim any authority over a trust that's managed and operated entirely in another state.
Yeah, she was laser focused on that connection, or lack thereof.
Now, Justice Kagan brought up a slightly different angle. She was wondering if the beneficiary could be considered to be receiving a benefit just from the fact that the trust's value was growing, even if they couldn't touch the money yet.
That's a tricky one. Like, is that theoretical increase in wealth enough to justify a tax? But then she flipped it around and asked why the beneficiary state should be the only one that can't tax the trust.
Yeah, why not the state where the trustee is or where the trust is administered?
Exactly. Chief Justice Roberts went back to the very basics, asking a surprisingly tricky question. How do you even determine where a trust actually is for legal purposes?
That's a good question. It's not like a physical building you can point to.
Right. And the lawyers had different answers, with the state basically saying a trust doesn't really have a fixed location, and the trust emphasizing the trustee's physical location and where the trust is managed.
Justice Alito got into the nitty-gritty details, asking about the trustee's discretion and what the beneficiary actually needed to live on.
Yeah, he was trying to figure out how much of the trust could be considered necessary for the beneficiary's support, which is tough to determine when the trustee has so much power.
It makes you realize how complicated these trust situations can get.
Totally. And then Justice Kavanaugh really wanted to know how common North Carolina's taxing scheme was. He asked how many other states did the same thing. The trust's lawyers made it pretty clear that North Carolina was an outlier, with Tennessee having no income tax and Georgia's approach being a bit of a question mark.
So they're really trying to isolate North Carolina, saying, look, no one else is doing this, so why should you be allowed to?
Exactly. And lastly, there was a lot of back and forth about what exactly a contingent beneficiary even means. North Carolina said it usually means something specific has to happen, like reaching a certain age, before you're eligible for the money. But the trust argued that the trustee's discretion was the main contingency, meaning the beneficiary was always in limbo, regardless of any life events.
So it all boils down to how much control the beneficiary has over the trust, right?
Yeah, and how certain their access to the money is.
Okay, now it's time to put on our thinking caps and step into the 10th chair.
The 10th chair.
That's our little segment where we pretend we're on the Supreme Court and offer our own perspective on the case.
So what's your take on this whole thing?
Well, from my 10th chair vantage point, this case really exposes this fundamental tension between a state's desire to tax everything it can get its hands on and the Constitution's protection against states overstepping their bounds.
It's like a battle between state power and individual rights.
Yeah, and this case really puts that battle on full display. While it's true that beneficiaries ultimately benefit from trust assets, at least in theory, the fact that they might not have any control over those assets right now or any guarantee of ever receiving anything makes North Carolina's tax scheme seem pretty shaky. Feels like they're reaching way too far trying to tax something that's not really theirs to tax.
So if you were casting the deciding vote, where would you lean? From my 10th chair, I'd probably side with the trust. I think a state's taxing authority should be tied to something more concrete, like where the trust is managed and controlled, or to the actual distribution of income to a resident. That seems much fairer and more in line with the whole idea of due process. It's like you can't just claim a piece of the pie just because someone who might get a slice someday lives in your state.
So it's about drawing clear lines and ensuring that states can't just go around grabbing tax revenue wherever they can find it.
Precisely.
Well, this deep dive into North Carolina Department of Revenue, the Kimberly Rice Kaestner 1992 Family Trust, has definitely been a wild ride.
It really shows you how complex these tax issues can get, especially when you're dealing with trusts in multiple states.
And it raises some really important questions about what limits there should be on a state's power to tax.
It's like, where does their reach end?
Exactly. And in an increasingly interconnected world, that's a question we're going to be grappling with more and more.
Food for thought.
We hope you've enjoyed this deep dive. And as always, thanks for joining us here at Talk Testimonies.